In these final lectures, we will be considering the question of the proper role that the court should play in the American democratic system, and we'll be approaching it from two different perspectives. In this set of lectures, we'll be talking about it from a theoretical perspective, and in the other set of lectures, we'll be talking about it from a practical perspective. But first, let's talk about it theoretically. So, any democracy has a fundamental conflict that it needs to resolve, and that's the conflict between majority rule and minority rights. Of course, a democracy is ruled by the people, and we assume that minorities should be able to do what they want. Majorities should be able to do what they want, but majorities shouldn't be able to trample upon the rights of minorities and persecute them. And so both of these values are important if a democracy is going to survive. And essentially, this is the conflict between independence and accountability. We want our government to be accountable to the majority, but we also want them to be independent from it. And this ultimately comes down to a question of who should make the law. Because in our government, we have some institutions that are more geared toward majority rule and some institutions that are more oriented toward minority rights. And of course, it's the presidency and the Congress that are oriented toward majority rule. They are the elected branches of government, and they are the branches of government where majorities get to carry out their will. It's the Supreme Court and the judiciary where minority rights can be protected. They're not always protected. In fact, for most of American history, the Supreme Court has not protected minority rights, but there have been periods of time where they have, and of course they can do this because they are unelected. They can't be removed except through impeachment, and as a result, they can make decisions that are unpopular. For example, they can say that flag burning is protected by the First Amendment even if that decision angers 80% of the American public. So the judiciary, by their lifetime appointment, is given the power to stand up for minority rights against the other two branches of government. But sometimes they can go too far, and what we're going to be talking about in this set of lectures is a debate between two different schools of thought about the proper role of the court in American democracy: judicial activism and judicial restraint. But to begin to understand these questions, let's take a look at the famous case of Griswold v. Connecticut, which was decided by the court in 1965. Griswold v. Connecticut had to do with a Connecticut law that made it illegal to use, to possess, or sell, or distribute any contraceptive devices. So condoms, birth control pills, or any other contraceptives were illegal under Connecticut law. And today, most people wonder when they hear about this case, why? Why would Connecticut pass a law like this today? Of course, the stress is on getting contraceptives more widely distributed. So why would Connecticut pass a law like this? Well, it was an old law, but they certainly had their reasons for doing so. First of all, for health reasons. This may seem counterintuitive because, of course, contraceptives can help prevent the transmission of sexually transmitted diseases. But the thinking was that if people don't have access to condoms, they'll be less likely to have sex, and then there's going to be less health problems associated with it because there's going to be more abstinence. It was also designed to discourage teen sexual activity. The idea was the teens would be less likely to have sex if they knew that they could possibly get pregnant or expose themselves to disease. It was also designed to discourage adultery, because the thinking was that men and women would not engage in adulterous affairs if it would result in the woman getting pregnant, which would reveal the affair itself. So these were the various reasons, and of course, moral reasons as well. Simply the idea that sex for pleasure is not something that should be done. So you may or may not agree with these various reasons. You may or may not agree with this particular law. But the question isn't whether this law is good or bad. The question is whether the state of Connecticut actually has the right, the power to pass laws like this, or whether laws like this are prohibited by the United States Constitution. So whether a law is good or bad is a different question from whether it's constitutional or not. Well, what did the court say in this case? Well, by a 7-2 vote, the court struck down the law. They said that it violated the Constitution. But the interesting thing, of course, is before the court can strike down a law, they have to identify what part of the Constitution it violates. They can't just say they don't like a law. It actually has to violate some part of the Constitution. And in this case, the court said that this law against contraceptives violated the constitutional right to privacy. There's only one problem here. If you take a look at the Constitution, you can read it from start to finish, and there is no right to privacy contained anywhere in the Constitution. So the court in this case struck down a law that was passed by the duly elected members of the Connecticut State Legislature based on something that wasn't even contained in the Constitution, something they simply made up. Now, the majority opinion, how did they come up with this right to privacy? Well, the majority opinion said that its decision was based largely on the Due Process Clause of the 14th Amendment. The 14th Amendment guarantees everybody due process by state governments. And it's interesting because, once again, we've talked about that this is a question of who should be making these decisions. Should it be the court, the undemocratic, anti-majoritarian branch of government, or should it be the legislature who is responsive to the people? And in the majority opinion, the court acknowledges this particular conflict, and they try to say that they're not substituting their own judgment for that of the legislature. William O. Douglas, in his majority opinion, wrote, "We do not sit as a super legislature to determine the wisdom, need, and propriety of laws that touch upon economic problems, business affairs, or social conditions. This law, however, operates directly on an intimate relation of husband and wife and their physician's role in one aspect of that relation." So he's saying here, hey, there are certain areas in which we will not tread that are given over to the legislature, things like economic laws and laws related to business affairs or social conditions, but some laws go too far, and striking them down is not an act of legislation, but it's something that must be done. So where exactly does the right of privacy come from? Well, Justice Douglas says, the foregoing cases, that is, their precedents, suggest that specific guarantees in the Bill of Rights have penumbras, formed by emanations from those guarantees that help give them life and substance. Now this is interesting. What is a penumbra? Well, a penumbra is a phenomenon that is mostly seen in astronomy. A penumbra is a partial shadow, as in an eclipse, between regions of complete shadow and complete illumination. So a penumbra, this is a really interesting analogy that Douglas has used, because when a solar eclipse occurs, the sun disappears. But we don't freak out these days. They used to in the past, but we don't freak out these days. We know that the sun is still there, and we partially know it because we can see the penumbra. So the penumbra is really a wonderful analogy here when it comes to the right of privacy, because like a penumbra, like the sun in a solar eclipse, the right to privacy can't be seen, but it exists. And we know it exists because its existence can be inferred from other things. There are other parts of the Constitution that don't exactly say the right to privacy, but when taken together seem to suggest that the framers believed that there was something like a right to privacy in the Constitution. So I think this is a wonderful analogy. Just as you can't see the sun during an eclipse, but you know it's there because of the penumbra, similarly, although you can't see the right of privacy in the Constitution, you know it's there because you can see other things that relate to the right to privacy. Now, what are those other things? What are the things in the Constitution that add up to the right to privacy? Well, the First Amendment, according to the court, is part of it because it contains a guarantee of freedom of association. And what is marriage and sexual activity with another person other than the most intimate form of association? In addition, they said the Third Amendment relates to the right of privacy, and this is really interesting because the court almost never decides cases with reference to the Third Amendment. The Third Amendment is a historical anachronism. It says that nobody can be forced to quarter troops, in other words, to host soldiers in their own homes during peacetime without their permission. Now, this was a problem 250 years ago. The King of England would have his troops, if they needed a place to stay for the night, they could just come to your house and take over your house. And so the Third Amendment was added to the Constitution to prohibit this. Again, this is not something that really ever happened, after the United States was founded, and so very, very few cases ever involved the Third Amendment. But nevertheless, the court said that it's important because what it suggests is the framers didn't want government agents being able to come into your home, and this is related to the right of privacy. In addition, the Fourth Amendment guarantees individuals protection from unreasonable searches and seizures. So again, this suggests that the framers thought that people had a right to keep certain things private and that the governments couldn't simply go through their personal belongings. In addition, you have the Fifth Amendment, which allows people to refuse to answer questions if they've been accused of a crime. Once again, the right to keep something private. So again, none of these things are the right to privacy by themselves, but the court said that all of them seem to relate to a concept of privacy. And then finally, there's a very, very important part of the Constitution, and that is the Ninth Amendment. And the Ninth Amendment is very important to individuals who we will soon call judicial activists. The Ninth Amendment says, "The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people." What this means simply is that just because we've listed rights in the Constitution doesn't mean that those are all the rights that people have. In fact, James Madison insisted on this particular amendment to the Constitution. He was worried that when they added the Bill of Rights to the Constitution, that later generations would think that the rights that were listed there were the only rights that Americans had. But in fact, Americans have more rights than are actually contained in the Constitution, and the Ninth Amendment specifically says that. And so the court said, well, the Ninth Amendment tells us that we have additional rights that aren't in the Constitution, and these other four amendments all seem related to a concept of privacy, and therefore together all of this adds up to the constitutional right of privacy. So, I'd like to have you stop and just think for a moment about whether you agree with this decision. Do you believe that there is a constitutional right of privacy that makes it unconstitutional for a legislature to pass laws restricting availability of contraceptives? If you do, then you may be a proponent of what is called judicial activism. Judicial activism is one approach for the way to interpret the Constitution. The question is, how should a judge act? How should a judge behave? What is the proper role of a judge? And judicial activists have very specific ideas about that. Judicial activists see the Constitution as a living document. They think it evolves over time. Of course, it was written at a particular time, but as conditions in society change, as understandings of social conditions change, the Constitution should change with it. And as a result, as we've seen, judicial activists are not strictly bound to the text of the Constitution. They see that adhering only to words doesn't take into consideration the consequences of a court's decision. And so what judicial activists try to do is they try to see the larger purpose behind the words. And so this really does become an interesting question about how do you interpret something? Do you interpret the words literally, or do you try to see what the meaning or intention of the words were? And judicial activists are very much inspired by the preamble of the Constitution. The preamble talks about the lofty goals of the Constitution. We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty. These are words the judicial activists take seriously, and they try to interpret the Constitution to carry out the goals contained in the preamble. And so when you see judicial activists writing, they will often talk about things like dignity and justice and liberty and equality, particularly equality and dignity, but also justice. And judicial activists, of course, take the Ninth Amendment very seriously. Judicial activists don't believe that they have to adhere strictly to the text of the Constitution. And in fact, the Ninth Amendment tells them that they don't have to. The Ninth Amendment actually commands anybody who reads the Constitution to go beyond the text of the Constitution, because it says Americans have rights that aren't listed here. And as a result, judicial activists tend to support minority rights. Now, we're going to talk later on about, how minority is defined, because minorities can also be rich people, but in more recent years, judicial activists, minority rights will include racial minorities, gay and lesbians, and so on and so forth. And so judicial activists, because they tend to support minority rights, they tend to overturn legislation and legislatures more often. Legislatures carry out the will of the majority, and so if you're supporting minority rights, then of course you're often going to come into conflict with the legislature. And so this is one definite hallmark of a judicial activist, is that they tend to overturn legislation more often. Now, what are some examples, some famous examples of judicial activism? Well, we've already talked about one. Griswold v. Connecticut is one of the classic examples of judicial activism, but there are others. Brown v. Board of Education. In Brown v. Board of Education, the court actually went against the original intent of the 14th Amendment, as we will talk about later on in this module. So Brown v. Board of Education, Griswold v. Connecticut, which we mentioned a moment ago. Roe v. Wade, of course, a classic example of judicial activism. The Constitution doesn't mention a right to an abortion. It doesn't mention anything about abortion. And yet, in this case, the court found that the right of privacy that they'd invented in Griswold v. Connecticut also covered a woman's right to choose. Obergefell v. Hodges, the case in which the Supreme Court overturned various laws defining marriage as being between a man and a woman, was a classic example of judicial activism. Legislatures wanted to do one thing with regard to marriage, and the court did exactly the opposite, and of course in doing so overturned literally hundreds of years of history. Now, the court, of course, in the Obamacare case, did not overturn Obamacare, but if they had, that would have been activism. Now, it would have been activism in a conservative direction. Now, that's interesting because the 4 cases that I have listed above here are all activism in a liberal direction, but overturning Obamacare would have been activism in a conservative direction. So this is important because it reveals that activism can be either liberal or conservative. This is not a necessarily ideological concept. Now, how does activism play out in the court's opinions? Douglas, in his majority opinion, has a classic statement that sort of expresses the beliefs of judicial activists. We deal with a right of privacy older than the Bill of Rights, older than our political parties, older than our school system. Marriage is a coming together, for better or for worse, hopefully enduring and intimate to the degree of being sacred. It's an association that promotes a way of life, not causes, a harmony in living, not political faiths, a bilateral loyalty, not commercial or social projects. Yet it is an association for as noble a purpose as any involved in our prior decisions. Justice Goldberg is even more classic. He says this. He addresses the issue of whether or not the court should be able to invent a right of privacy even though it's not in the Constitution. He addresses this specifically. And he says, although the Constitution does not speak in so many words of the right of privacy in marriage, I cannot believe that it offers these fundamental rights no protection. The fact that no particular provision of the Constitution explicitly forbids the state from disrupting the traditional relation of the family, a relation as old and as fundamental as our entire civilization, surely does not show that the government was meant to have the power to do so. Rather, as the Ninth Amendment expressly recognizes, there are fundamental personal rights such as this one which are protected from abridgment by the government, though not specifically mentioned in the Constitution. So he says, look, just because the Constitution doesn't mention this doesn't mean it doesn't exist. And of course, he points out the Ninth Amendment. We are commanded to create new rights from time to time. Now, you probably agree with this. You are a modern person in the early 21st century, and you probably think that these laws against contraception are archaic. And so the question you might be asking at this point, so what's the problem? Why, judicial activism sounds pretty good to me. Well, there are people out there who believe judicial activism is fundamentally wrong. And in our next lecture, we'll talk about what they have to say.